All right. Now, do the attorneys have any pretrial matters starting with the prosecution?
Yes, Your Honor. Before we begin, we'd like to tender a few documents to the bench. This includes the special instructions, the indictment, the stipulations, the orders on motion in limine, the case law, and the case documents. Opposing counsel has seen this binder and has raised no objections.
I appreciate it, but I already have those documents, so if I find a page missing, I'll rely on you. Thank you.
Yes, Your Honor, that sounds perfect.
Any other pretrial matters?
At this time, Your Honor, we'd like to invoke Midland's Rule 615, which calls for the constructive sequestration of all witnesses barring party representatives. The prosecution today has no party representative.
All right. Without objection, that motion is granted and the witnesses are deemed constructively sequestered. Any other pretrial matters?
One last thing, Your Honor. We'd like to bring the court's attention to actually a piece of relevant Midland's case law, United States versus Shaw. It's on page 1 of the case law. Your Honor, today the prosecution is pressing 3 charges against the defendant, Parker Barrow: bank robbery, armed bank robbery, and conspiracy. And if I may, Your Honor, read a portion of this case law for the court.
I have the excerpt from the case law right in front of me. That's just fine. Thank you.
Yes, Your Honor. And at this time, we're ready to proceed.
Very good. Any pretrial matters for the defense?
Yes, Your Honor. For a few pretrial matters. First of all, Mr. Barrow will be sitting at counsel table throughout trial, just for the court's notice.
That's just fine, and it's understood.
Also, Your Honor, may I approach and tender the notice of intent to offer character evidence? Both parties have seen this and signed this document.
You may. The court takes note of the notice, and we'll wait and see how that affects the trial.
Yes, Your Honor. If I could direct your attention to the pretrial order, which I believe you said that you have.
I do have it.
Your Honor, under pretrial order number 9, it clarifies that the Midland's rules of evidence will govern this trial. Now, this is a federal trial. However, the court has decided that for evidentiary proceedings, the Midland's rules of evidence will govern it. They do differ slightly from the federal rules, but I believe you have a copy, Your Honor.
I appreciate that. The court is most familiar with the federal rules of evidence, so to the extent there are any differences that are relevant that you wish to point out during the argument of any objection, the court would appreciate it.
Yes, Your Honor. And then if I could direct your attention to pretrial order number 9. It states that the court has considered and overruled all confrontation clause objections, also known as the Crawford case, except as to statements made to law enforcement. This, of course, does not preclude other hearsay objections throughout trial.
The court is aware of paragraph 9 of the pretrial order and will be governed accordingly.
And then just a few housekeeping items, Your Honor. Do we have permission to move freely about the well during statements and examinations?
All attorneys are perfectly free to move around the well of the courtroom without permission. Of course, ask for permission before approaching the bench or a witness.
And with that, the defense is ready to go, Your Honor.
Very good. Thank you. Counsel for the government, please proceed with your opening statement.
Yes, Your Honor. May I proceed?
You may.
May it please the court, opposing counsel, members of the jury. It's October 31st, 2017. 2 people walk into the Third National Bank in Midland City. They're wearing masks and holding guns, and they take $31,500 in cash from the only teller behind the counter. But before they can leave, the police arrive, tell them to drop their weapons, seize their cash, and arrest them for robbing the bank. But what the police didn't know at the time is that that wasn't an ordinary bank robbery. It was planned. The teller behind the counter was in on it. Members of the jury, that teller was the defendant, Parker Barrow. That's because the people on both sides of the counter were on the same side of the crime. But you'll learn that this crime didn't begin with the defendant. It actually began with the criminal mastermind, a woman whom the police have never found. And they call her Jane Doe. And you'll learn that Jane Doe recruited all of the participants in this crime. We'll call one of the robbers whom Jane Doe recruited She'll tell you that from the beginning, this crime was going to be an inside job, and that Jane Doe had recruited an insider, the defendant. And today you'll learn how they were all going to communicate with each other. Because that robber is going to tell you that everyone involved in this crime used a specific kind of cell phone, a red flip phone. And that just 1 week before the robbery, she saw the defendant with an identical red flip phone. We'll then call an eyewitness to the crime, a customer at the bank who was there during the robbery. She'll tell you that on that day, the defendant was the only teller working behind the counter, and that just a few weeks before, she had seen the defendant meeting with Jane Doe. And today you'll learn why they met. Because Jane Doe needed the defendant to do two things to ensure that those robbers didn't get caught. First, the defendant would move the bank's security camera so that it faced away from the lobby where the robbery would occur. And second, the defendant wouldn't activate an alarm during the robbery, an alarm that would have alerted the authorities to this crime. And you'll learn why the defendant did all of those things, because he was going to get a cut of the cash that the robbers took. You'll learn that on the day of the robbery, the defendant was given a red envelope full of cash from the only customer who was in the bank at the time. You'll learn that the FBI never recovered that envelope. The woman who deposited it never got it back. There's still money from this case that's unaccounted for. And you'll learn that the last person who was seen with that envelope was the defendant. The people on both sides of the counter were on the same side of the crime. And because of that, we, the government, have brought 3 charges against the defendant: bank robbery, armed robbery, and conspiracy to commit robbery. But the only charge that you, the jury, will have to consider is that last one, whether the defendant conspired to commit robbery. Because you'll learn that another court has already held that as long as we can prove beyond a reasonable doubt that the defendant conspired with the robbers to commit this crime, then he'll be just as guilty of those other 2 charges, even if he wasn't the one holding the gun. And we will meet that burden, members of the jury. And at the end of this trial, we'll ask you to find the defendant guilty. Because the people on both sides of the counter were on the same side of the crime. Thank you.
Thank you, counsel. Counsel for the defense, are you ready with your opening statement?
Yes, Your Honor.
Proceed when you're ready.
May it please the court. Parker Barrow had everything to lose and nothing to gain. Members of the jury, Parker Barrow needed nothing. So why? Why would he risk everything? That's the question the government cannot answer today. It's not the only question, but a critical one. What was his motive? For a cut of less than $8,000, they want you to believe that Mr. Barrow gave up a life of following the law to commit a life-altering crime. It doesn't make any sense, and it still won't by the end of this trial. The government's burden today is the highest in our legal system. Proof beyond any reasonable doubt that Mr. Barrow conspired to rob Third National Bank. And they'll try to meet their burden with nothing more than a partial print and a prisoner who took a plea deal. That's right. The surveillance footage from the bank captured nothing. A search of Parker Barrow's home found nothing. An incentive? Parker Barrow stood to gain nothing. You're going to hear that the government's evidence is nothing near what it would take to meet their burden. Now, there are witnesses who saw and who heard things on and before the 31st that the government will not call. And they won't call them because they point to a different suspect, one the government didn't fully investigate. testimony will suggest that there should be a different man sitting in that chair. That Cassidy Sutton, Third National's manager, should be sitting in that chair. Our first witness owns the restaurant right across from Third National Bank. Miss Patty Dillinger will tell you about seeing the robbery unfold outside the bank and recognizing two of those robbers from a meeting she saw just 1 week earlier. She'll tell you that she did see a bank employee meet with those individuals, but it wasn't Parker Barrow. Cassidy Sutton was the one she saw meet with two of the known bank robbers just 1 week before the robbery. You're also going to hear from Parker Barrow today. The government will get their chance to challenge his motives and try and establish that he needed this money and was willing to commit a crime to get it. But as you listen to his testimony, you'll see that it's consistent with what the rest of the evidence will show. He had everything to lose and nothing to gain. You're also going to hear from Dr. Harper Karpus. She's an expert criminologist who will explain to you that Cassidy Sutton had the most critical element in this case: access to the bank and its security system. You're going to learn that the insider used in this robbery had intimate knowledge of that security system and moved that camera after hours. Dr. Karpus will explain to you that the FBI's investigation into this case was too narrow, and it failed to fully investigate all possible suspects. Members of the jury, we're going to ask you to remember that it's the government with the burden today. We do not have to prove to you that Cassidy Sutton was the inside man. They have to prove that he wasn't. More than that, they must prove to you beyond any reasonable doubt that the only person who could have committed this crime was Parker Barrow, and that he actually did it. And that's where the government will fail. Someone in Midlands may have needed the money that badly. Someone in Midlands may have been willing to risk everything, but there is nothing to suggest that that person was Mr. Barrow. This man. This man was a victim, not a voluntary participant. He was inside the bank, but he was no insider in this robbery. By the end of trial today, it will be clear that he had everything to lose and nothing to gain. We will ask you to find him not guilty. Thank you.
Thank you, counsel. Timekeeper, do you swear the witnesses? Do you swear the witnesses? Counsel for the prosecution, would you confirm that the witnesses were sworn before the trial began?
Yes, they were, Your Honor.
All right, in that case, are you ready to call your first witness?
Yes, Your Honor. The prosecution calls Miss Charlene Floyd to the stand.
Ms. Floyd, please come forward. You've already been sworn.
May I proceed?
You may.
Good evening. Could you please introduce yourself to the members of the jury?
Shaw, hi. Charlene Floyd. It's nice to meet you.
Ma'am, where are you from?
I was born on the south side of Midlands, but I bounced around a lot as a kid. I really wouldn't say I'm from anywhere specific.
What do you do for a living?
I mean, last year I was working over at the French Toast Chalet. It's a 24/7 diner, kind of like a Denny's, I guess, but a little cheaper. I mean, I didn't love the job, but, you know, it paid the bills.
What do you do now?
Well, right now I actually don't have a job. I'm living over at Midland State Correctional right now.
How'd you end up there?
I was involved in the robbery on Third National Bank last October. I pled guilty. I asked for a plea deal.
Ma'am, why did you ask for a plea deal?
I didn't want to be in on this robbery in the first place. If I knew something, I wasn't going to keep quiet about it.
Well, what kind of information did you know?
I didn't do it alone. And I figured, if I could tell the police about who I was working with, maybe I could get some time off.
Did you end up getting that plea deal?
I did, yeah. That's why I'm here.
Ma'am, I want to talk about that robbery. Now, you mentioned a moment ago that you didn't want to do it in the first place. So how'd you get involved?
I was taking a smoke after work one day. It'd been a long day. I'd been waiting a lot of tables, and this Jane Doe lady just, comes up to me out of the blue.
Would you recognize a sketch of that woman if I were to show it to you today?
I sure would, yeah.
Let the record reflect that I'm now approaching opposing counsel with what has been previously marked as Exhibit 10. May I approach the witness?
You may.
Thank you.
Ma'am, what did I just hand you?
This looks like a sketch of the lady that came up to me, that Jane Doe lady.
Fair and accurate?
I'd say so. It looks just like her.
At this time, the prosecution moves to enter Exhibit 10 into evidence.
Exhibit 10 has been offered. Is there any objection?
No objections, Your Honor.
Exhibit 10 is received.
Ma'am, after this woman walked up to you, what happened?
She tried to get me in on some plan to rob a bank.
And how did you respond to that?
I said, no, are you stupid? I might have worked at knockoff Denny's, but, this was my first stable job in a while. I wasn't trying to give that up.
How did Jane Doe respond?
Well, she threatened to tell my boss about my past if I, didn't help her.
What was your past?
I've been lost in the system since I was a kid. I don't really know what to say, I bounced around a lot as a kid, as I mentioned. I grew up, juvie, foster care, group homes, all three. I got in trouble with the police a couple years back. When I applied for this job, I didn't tell my boss about any of it. I didn't think I'd get the job if she knew, but, she didn't ask, and, I didn't tell her.
So what did you do?
Well, at that point, I felt like I didn't have a choice. I couldn't lose this job. Like I said, I needed the money to pay my bills. I just agreed to help her out.
After you agreed to help Jane Doe, what happened?
She put this cheap-looking flip phone in my hand, and she left. And just after that, I did whatever she told me to do.
Would you recognize a photo of that phone if I were to show it to you today?
Yes, I would.
Let the record reflect that I am now approaching opposing counsel with what has been previously marked as Exhibit 6. May I approach the witness?
You may.
Thank you, ma'am.
Now, Miss Floyd, what did I just hand you here?
This is a picture of the phone that Jane Doe gave me.
Fair and accurate?
I'd say so, yes.
At this time, the prosecution moves to enter Exhibit 6 into evidence.
Exhibit 6 has been offered into evidence. Is there objection?
No objections, Your Honor.
Exhibit 6 is received.
Miss Floyd, what did you do with this flip phone?
It was just a flip phone. I only used it the bare minimum right when I had to talk to Jane Doe and the other girl, M, who we met with and was in on the plan.
Now, you mentioned a moment ago that you did what Jane Doe told you to do. What's the first thing that you ended up doing for her?
I had to go scope out Third National Bank. So I went October 24th. It was a Tuesday at 11 a.m.
I'd like to talk about October 24th. What did you notice when you got to Third National Bank?
First thing, right away when I walk through the door, I look up, I see this security camera sitting on the ceiling. It's pointing right down towards the teller's desk.
Did you see any customers at the bank?
Sure did, yeah. There was one standing at that desk. She looked like a real nice lady, a real, Miss Moneybag. She had this big red envelope with her. It was filled with cash.
Did you see any employees at the bank?
I did, yeah. I saw two of them. There was a teller helping out that nice-looking lady, and there was some guy off in some back office.
So how did you proceed?
At that point, I didn't want to look too sketchy, right? I was standing at this bank, so I went up to the teller. I tried to deposit my tips.
And what happened after that?
I mean, I was just, standing there for a little bit, waiting for my deposit receipt, looking around, la-di-da, and I looked down at the teller's desk, right? And, sitting right there in front of the teller is this cheap-looking flip phone. It looks just like the one that Jane Doe gave me.
How did that phone look in comparison to Exhibit 6?
It looked exactly the same. It had these, little red stripes in the corners and everything.
Do you know who the teller with the phone sitting right in front of him was?
I didn't know at the time. I now know that that person is the teller, Parker Barrow.
Do you see the teller, Parker Barrow, here in court today?
I do, yeah. He's got the nice maroon tie and the gray suit over there at the table.
Let the record reflect that the witness has identified the defendant. So after you scouted out the bank on October 24th, what did you do?
Well, I went back and told Jane Doe about what I saw.
Did you have any concerns?
Yeah, I mean, there was that camera that I saw right when I walked in, and I was really wondering about that phone that I saw.
How did Jane Doe respond?
She didn't seem concerned, actually. She said, "We have an insider, actually. It's the teller, Barrow."
Objection, hearsay.
Response?
Yes, Your Honor. The statement made by Jane Doe is a hearsay exclusion under Rule 801 D2E. It's a statement made by a co-conspirator. And pursuant to Midland's case law, United States versus Owens, we may conditionally omit this statement, and we have until the end of trial to prove by a preponderance of the evidence that Jane Doe indeed was a co-conspirator.
So you're not saying the preponderance exists at this moment?
No, Your Honor.
Response?
If I may, first under 801 D2E, it must be a co-conspirator to Mr. Barrow, not a co-conspirator to this mastermind, Rose. We have heard no foundation that, in fact, this was a co-conspirator to Mr. Barrow. That is the first issue.
Is he right, counsel?
Your Honor, we have until the end of trial to prove that the 4 individuals involved in this robbery were all co-conspirators.
She's saying she's going to do it conditionally. What do you say to that?
Your Honor, actually under U.S. v. Owens, it says that it is up to Your Honor's discretion to admit this. And as Your Honor knows, the jury can't unhear evidence that is said here in court today if it is conditionally admitted. Counsel should first lay that foundation so we can establish that conspiracy before the statement could come in. And Your Honor, I have a good faith basis to believe that they will not be able to lay a foundation to link a co-conspirator to Mr. Barrow.
Can we unring the bell with the jury, counsel?
Excuse me?
Can we unring the bell? In other words, they hear it and then I tell them later to disregard it?
I'm not sure, Your Honor, but we may conditionally omit this statement pursuant to the United States versus Owens case law.
Anything further?
Yes, Your Honor, you are correct. We cannot unhear this testimony, Your Honor. So this statement should not be elicited.
We have an extraordinary jury tonight, and I think they'll disregard whatever I tell them to disregard. The objection is overruled.
Yes, Your Honor.
Yes, Your Honor. Now, ma'am, was that the last time you saw that teller?
No. The next time I saw him was the day of the robbery. That was October 31st.
I'd like to talk about the day of the robbery. How many employees did you see when you got to Third National Bank?
Just one, Mr. Barrow.
Was that security camera still facing the teller?
No. This time it was pointed up towards the ceiling.
Did you see any customers at the bank?
Yeah, that same nice lady from the week before. She was standing at the teller counter again, making a deposit.
So how did you proceed?
I came in, right? I was with my partner, M. We had masks on. I had a gun in my waistband. I come in, I say, everybody be cool, right? This is a robbery. And, Miss Moneybags, that nice lady, she turns around. She looks a little spooked, honestly. And I just told her, I didn't want to hurt her, but I told her, sit down, give me a phone, and just be quiet.
And what happened after that?
Well, after that, my partner, she goes up to the teller's counter to Mr. Barrow, and she puts out a bag, and Mr. Barrow very nicely just fills it up.
And how did the defendant seem to you during this interaction?
I mean, he didn't look nervous. I mean, his hands weren't shaking, and, his face was very calm, very, very calm, very cool as a cucumber, honestly.
And what happened next?
Well, after that, I guess you guys probably can figure out what happened next. Next thing I know, the police are storming in. I'm in handcuffs. I'm being shoved in a police car. I lost my job that day. I lost my life.
Ma'am, I want to talk about one last thing. Now, earlier you mentioned you saw a bank customer with a red envelope on October 24th. On October 31st, did you see that same bank customer with a red envelope?
I did, yeah. I mean, it looked